So to Article 37 now, you know the clause, it's the saver clause. And first of all, somebody asked me actually earlier on today, that person that I was referring to, who is clearly absolutely on this topic. So this is now the second question. Really, the question is what counts as a limited function or power of a judicial nature for the purposes of Article 37(1) of the Constitution? Like that's possibly the biggest question in Zalewski. Remember now that Thomas Zalewski himself has kind of won on the Article 34 point. He was saying all along, this is the administration of justice, as far as Article 34 is concerned. And a majority of the judges have agreed with him and said, yes, you're right. Now, the Constitution says, well, then it should be done by a court, not by the Workplace Relations Commission, and by judges who are legally trained and independent, not by these people on the Workplace Relations Commission who, many of them, most of them aren't lawyers, and so on. So he wins. The question is now, does that mean that WRC can't exist effectively? Do you know that it's unconstitutional? And of course, as you know, I think the answer is no. And the reason is because of Article 37. It's saved by the saver clause. It's saved from unconstitutionality by the saver clause. So we've looked at the text of the saver clause already. Okay, fine. So what counts as a limited function or power of a judicial nature for the purposes of that clause, right? That's the key question. What counts as limited? And, you know, again, a bit like in the Article 34 thing, there was an established approach to this question. And it was established around the same time in the mid-20th century in a case called Re-Solicitors Act by Kingsmill Moore, Judge Kingsmill Moore in that case. And it applied all the time, every year since, right? All the way through the 1970s, 1980s, 1990s, all the way through the 2000s. And until it came along to Zalewski. And Judge O'Donnell transforms it in Zalewski, really kind of turns it on its head. And to summarize, I would say that following from Kingsmill Moore's position there's the clause, by the way, for the purposes, I guess, of the video, you guys will have seen this already. Okay, nothing in this Constitution shall operate to invalidate. And really that means Article 34, Section 1 shall not operate to invalidate the exercise of limited functions and powers of a judicial nature in matters other than criminal matters by a person or body of persons duly authorized by law, the Workplace Relations Act 2015, for example, or the Greyhound Industry Act 1958, for example, or any one of a million provisions of legislation all across the administrative state, to exercise such functions and powers, notwithstanding that such person or body of persons is not a judge or a court. Okay, that's the saver clause. And historically, oh yes, now let me, before I get into Re-Solicitors Act, let me remind you of these two provisions. All right, this is, now things are getting technical. Things are getting technical. 34, Section 3, subsection 1, and 34, Section 3, subsection 4. These deal with the jurisdiction of what we're going to call Article 34 courts. As it were, proper courts, like the Labour Court, for example. It's called a court, Labour Court, but it's not an Article 34 court. It's a tribunal. Anyway, 34(3)(1) says the courts of first instance shall include a high court vested with full original jurisdiction. Full original jurisdiction in and power to determine all matters and questions, whether of law or fact, civil or criminal. Right? So that's the jurisdiction of the High Court. It's a very broad jurisdiction. It's not a limited jurisdiction. It's a very broad jurisdiction. You think about what the High Court does. Look at the various lists, High Court lists, across all kinds of areas of law: commercial law, immigration, judicial reviews, well, criminal jurisdiction, obviously, the Central Criminal Court, and tort law, contract law, constitutional law, reviewing validity of legislation for constitutionality, for example, and so on and on and on and on, right? The jurisdiction is vast. Then look at the jurisdiction of the other courts of first instance. Obviously, we're thinking here about the district court and the circuit court, which are lower courts. The courts of first instance shall also include courts of local and limited jurisdiction, with a right of appeal as determined by law. Right? So there's a Courts Act, as amended, which vests particular jurisdiction in the district court, and it limits it. Now, I don't know what that is. Like I said to you in class last week, what are the limits on the remedies that, for example, the district court can hand down? I don't follow that kind of thing, but it's obviously limited. And, they can't deal with, for example, serious criminal matters, for example. Like so. Or for example, yeah, I mean, its jurisdiction is very limited, right? And it's governed by law, by legislation. So just bear those provisions in mind, because you'll see that there's a word that appears in 34.3.4, the word limited appears there, right? The same word, limited, appears in Article 37, Section 1, as you know. Limited, you see it there? It's obviously a really important word, limited functions. In fact, the whole provision rides on it and what that means. So this, in a sense, kind of goes back to our previous topic, which is how to interpret the Irish Constitution. Do the words mean what they appear to mean? Or if the word limited appears there, why would it mean something different in this context than that context? Or should you read it in its context? Contextual purpose of interpretation or literal formalist interpretation, etc. Anyway, in this case, Re-Solicitors Act, historically, as it happens, decided in 1960, and it concerned the Solicitors Act 1954, which was a provision of legislation, obviously, passed by the Oireachtas in 1954, obviously. And basically, what it did was it lifted a part of the, ironically, the historical jurisdiction of the High Court, supervision of the solicitor's profession, disciplinary matters relating to the, let me just stop share for a second. It can get boring to look at the same screen all the time. That was always part of the historical jurisdiction of the High Court, right? The High Court was responsible for supervision of the discipline of solicitors, right? And in 1954, on foot of that legislation, that was vested in the Law Society, right? So the disciplinary committee of the Law Society now had the authority to ultimately actually to strike off solicitor, right? So if the solicitor breached the various regulations regulating the solicitor's profession around handling clients' money and so on. And these two solicitors were struck off by the disciplinary committee of the Incorporated Law Society, I guess in the late 1950s. And they went to the High Court and they argued that that breached Article 34, that the disciplinary committee of the Law Society was doing something that should be done by the High Court. It was administering justice, right? And I suppose more to the point, that it was not limited power and function of a judicial nature in the sense contemplated, as it were, by Article 37, Section 1. And it goes to the Supreme Court, and Mr. Justice Kingsmill Moore, you see him here, Mr. Justice Kingsmill Moore, again, a somewhat run-of-the-mill case, but he gives us a very eloquent account of how to approach the meaning of the word limited in Article 37, Section 1. And what he does essentially is he looks at two possibilities. that the word limited in Article 37.1 could be understood to refer to jurisdiction. Or on the other hand, it could be understood to refer to effect. And by that I mean, it could be understood to mean, well, limited effect, that the effect of a particular power when exercised on, for example, your interests, your life, your liberty, your reputation, your financial resources, that's what is intended or meant by the phrase limited in Article 37, Section 1. Or it could mean limited jurisdiction, in the sense that the word in Article 34.4.3 refers to limited jurisdiction. You see, so in 34.3.4, I should say, the word limited evidently and obviously refers to the jurisdiction question. Right? So it could mean that, or it could mean effect. And essentially, Kingsmill Moore opted for the effect. Now, funny enough, this goes back to our discussion in class, particularly actually on the Friday class. I think it was last Friday, it was actually Chelsea. We had this discussion. I can't remember, it was one of those discussion documents. I can't remember exactly what we were talking about. Wasn't the Land Commission case? It might have been the sharing images online. I can't remember exactly. But she kind of said, well, that should be done by a court. And I asked her why. She's possibly on the call right now, but I asked her why, and she began to talk about it. And basically she said, well, it has a big impact on somebody. This is their career. This is their livelihood. This is their reputation. And it's it was very, for the record, it was very, good analysis on Chelsea's part. And funnily enough, it was getting, even though she hadn't, presumably, this was all new, it was getting to the heart of the matter, right? What she was kind of getting at the same idea that Kingsmill Moore got to in Re-Solicitors Act. Basically, she said, this is a big deal. Or if you think about that case that's before the Teaching Council right now this week that I referred to at the start of the class, which I just happened to read about on the paper yesterday. The school principal in the west of Ireland and the substitute teacher or student teacher, whatever she was, that's a big deal. That's a very big deal. There's reputations on the line. There's careers on the line, fitness to teach, etc. Essentially, anyway, Kingsmill Moore said in Re-Solicitors Act, if the process that is impugned, the decision-making body in question is making decisions that have limited effects on the lives and reputations and livelihoods and so on of the individuals in question, then it's saved, then it's okay. But if the effect of the power when it's exercised on the lives and reputations of the person is significant, then it's not saved. So that's what limited means in Article 37, Section 1. Limited effect, right? So effect wins as far as Kingsmill Moore is concerned in Re-Solicitors Act. And I suppose, I don't know what you think about that, but it's very intuitive. It makes a hell of a lot of sense. It seems to be the obvious rationale or purpose of 37.1. In other words, you can do stuff in non-judicial bodies or non-courts, so long as it's not that important. So long as it doesn't have much of an effect on the people in question. And basically, so let's see his rationale, right? I'm sorry, now there's a lot of text here. He says, this is Kingsmill Moore in Re-Solicitors Act in, I think, 1960. What is the meaning to be given to the word limited in 37.1? It is not a question of limited jurisdiction. Limited jurisdictions are specially dealt with in 34.3.4. It is the powers and functions which must be limited, not the ambit of their exercise. Nor is the test of limitation to be sought in the number of powers and functions which are exercised. The Constitution does not say powers and functions limited in number. A tribunal, like the WRC, by the way, having but a few powers and functions, but those are far-reaching in effect and importance, could not properly be regarded as exercising limited powers and functions. The judicial power of the state is by Article 34 lodged in the courts, and the provisions of Article 37 do not admit of that power being trenched upon or of its being withdrawn piecemeal, bit by bit, from the courts. The test as to whether a power is or is not limited, in the opinion of this Supreme Court, in this case, Re-Solicitors Act, lies in the effect of the assigned power when it is exercised. If the exercise of the assigned powers and functions is calculated ordinarily to affect in the most profound and far-reaching way the lives, liberties, fortunes, or reputations of those against whom they are exercised, then they cannot properly be described as limited. Now, you're reading that and you're probably thinking, well, that makes sense. And I suppose what I would say to you is that John McManaman, in his dissent, it makes sense to him as well. He likes it. Because I guess, what does it imply? It implies that Article 34 is kind of, now it's a kind of a really limited reading of it. It's a very, what's the word? Limited, ironically. No, I mean, it's a narrow reading of it, right? And that's appropriate maybe for a saver clause, because what Kingsmill Moore is saying is, look, Article 34 says justice is administered in the courts. That's not going to be withdrawn piece by piece, bit by bit. That's the linchpin clause. The other one is just a saver clause. This just applies and operates to save stuff that has mild effects on people's lives and reputation. If it's got a big effect on people's lives and reputations, then it's not saved. And part of, I suppose, his reasoning is that he says, well, look, sorry, a second. He says the jurisdiction limitation, that's already referred to in 34.4.3, I think it is. Oh, sorry, I keep saying that, 34.3.4. So the word as it is used in 37.1 must have a different meaning. Okay, it refers to jurisdiction there in 34.3.4. So it must refer to effect in 37.1. Now, it kind of maybe seems there's a certain logic to it, but is there either? Why would it mean different things in two different constitutional provisions? Why would it not maybe refer to the same thing, to jurisdiction? And effectively, I guess, the impact of the Kingsmill Moore judgment in Re-Solicitors Act was that Article 37.1 more or less disappeared from the stage in Irish constitutional law, because it was only there to save provisions, or sorry, processes that didn't really need saving in the first place, because people don't tend to go to court to challenge the authority of bodies to make decisions when those decisions have mild effects on them. They don't have far-reaching effects on them. You know, it's like, well, why would I bother going to spend all that money going to court to challenge the authority of a body to make decisions in respect of me when the decisions don't really bother me anyway? Right? So it went out into the constitutional shade for 5 or 6 or 7 decades. And Donald O'Donnell, I mean, by the way, think about the WRC for a second. Think about the WRC and Zalewski, for example. I mean, is that making decisions that have limited effects on people's lives and livelihoods and reputations? Of course not. I mean, there was a suggestion, an implication, clearly, that Mr. Zalewski had done some pretty dodgy stuff in the course of his employment relating to the cash in tills and so on. His reputation was on the line. His livelihood was on the line. So clearly and that's the case. I mean, look at what's going on in the Teaching Council. I keep referencing it. What's going on in the Teaching Council this week? I'm sure there's loads of other fitness to teach. Actually, come to think of it, isn't there another big story in the news recently about a teacher in a school in Dublin who, and I don't know, there's a stay on that disciplinary hearing, but isn't that inevitably going to come to probably some class of a fitness to teach analysis? Her reputation is on the line. her career is on the line. Do you know? So is Article 37 going to save the authority of the disciplinary committee of the teaching council or whatever? Well, no, it's not, if it means what Kingsmill Moore says it means. So in that sense, Article 37 kind of faded from view and became less and less important. And until, I suppose, the Zalewski judgment. And then Donald O'Donnell, I suppose, look, ultimately I'm saying you clearly should read. I think it's probably easier, actually. The 37 element of Zalewski is probably easier than the Article 34 element. And what I'm saying to you is you should absolutely read the paragraphs in the judgment where the judge, Donald O'Donnell, goes through his analysis as to the meaning of the word limited in Article 37. And one of the things he says, and actually, funny enough, I was going to bring this up a long time ago and I forgot about it, but that guy that got in touch with me this week about various things and wanting to read various articles and so on, he said to me, why was Article 37 included in the text of the Constitution in the first place? Funny enough, there aren't actually equivalent provisions. It's quite unique, I think. Maybe not unique, but I'm not aware of any equivalent in any other constitution. In the US Constitution, for example, Australia, Canada don't have equivalents. So why do we have this interesting little clause, 37.1? And the reason, I think, was because of the Land Commission. Right? The Land Commission was in full swing in the early 1930s. I think, as I said to you before, I think the Land Commission was operational from the late 19th century, if I'm not mistaken. But anyway, it was in full swing in the early 20th century. And there was that case that I mentioned, Lynham and Butler number 2 from 1933, which is very significant in Donald O'Donnell's judgments in Zalewski, Lynham and Butler number 2. Basically, it was a dispute between these two men, Mr. Lynham and Mr. Butler, as to the ownership of land, basically. And one of them challenged the authority of the Land Commission to make the decision that it made. But the Land Commission, of course, was enormously important in Irish economic and social, in the Irish economy and society of the period. The Land Commission was transforming rural Irish life, and distributing land to tenant farmers, essentially, undoing, as it were, let's say, the damage that had been done by landlordism, colonialism, etc. Right? So this was an enormously important development. And there was this dispute about it. And one guy goes to the High Court and eventually to the Supreme Court to say, look, this Land Commission is doing something that the courts should be doing under the Free State Constitution. I think it was Article 64 of that Constitution. And the judges on the Supreme Court took his claim very seriously and seemed to decide the case in his favor. And that kind of, David Gwynne Morgan says, that shook the body politic to the core. In other words, the drafters of the Constitution, De Valera, etc., said, okay, well, we need to make sure that the Land Commission is constitutionally safe. And I suppose the Revenue Commissioners, for example, it does stuff that might walk and talk a bit like the administration of justice. But we need the Revenue Commissioners to be able to do that work in order to collect the tax and so on. So let's put a little saver clause in there. And that's how 37.1 came about. But Donald O'Donnell makes this point in his judgment in Zalewski. He says, well, look, if you think about it, when drafters of Article 37.1 drafted that provision, they had the Land Commission in mind. Did they think that the decisions that the Land Commission was making were decisions that had mild effects on people's lives and livelihoods? Not at all. I mean, the Land Commission was making decisions that had obviously huge effects on the lives and livelihoods of the people who it affected. And similarly, the Revenue Commissioners. So Donald O'Donnell is kind of rethinking the logic of Kingsmill. He's saying Kingsmill Moore, I'm not sure he's right, basically, he's saying, and essentially what he does in his Zalewski judgment is he reverses the logic of Kingsmill Moore from that case, Solicitors Act, right? Whereas under Kingsmill Moore, the effect is the winner. Article 37.1 limited is understood to mean limited effect. Whereas under the O'Donnell judgment in Zalewski, there's a new test for Article 37.1, and basically jurisdiction is now the winner, if you like. Okay, it's being read as referring to jurisdiction, right? So the district court has a limited jurisdiction by comparison to the full original jurisdiction that the High Court has, right? It's much more limited in what it can do. And similarly, says O'Donnell, there's no reason why, all because 34.4.3 refers to limited jurisdiction, that 37.1 doesn't also refer to limited jurisdiction. And he says the WRC does have a jurisdiction that is limited in all kinds of ways by comparison to the High Court. So now what we're seeing, the Zalewski test on Article 37.1, what we're seeing really is that it's the word limited in 37.1 is being understood with reference to the full original jurisdiction that the High Court enjoys. That's the contrast. The question is its jurisdiction limited by comparison to the jurisdiction of the High Court? If it is, and it's sufficiently limited in the view of, I guess, the judges in a given case, then it might be saved or can be saved by the saver clause, Article 37.1. And in a sense, what you're seeing really is all these non-judicial bodies, the Workplace Relations Commission, obviously, I guess the what's it called now? The Refugee Appeals Tribunal. It's now called the IPAT, the Immigration Protection Tribunal, and all of the revenue commissioners and all of the Teaching Council, the Disciplinary Committee of the Law Society, and all of the dozens upon dozens upon dozens upon dozens of others. Let's call them tribunals, commissions, and so on. They're now being understood as Article 37 tribunals, right? They're exercising limited powers of a judicial nature, but they're saved from unconstitutionality by Article 37. And they're more like, if you think about, John McManaman is deeply concerned about this, because what he's saying is effectively these tribunals are being elevated in status almost to the status of the district and circuit courts, you know, even though they're not courts and they don't have judges. I'm just going to stall the recording. I do have more things to say to you. I appreciate it's coming up to home time, but I do have one or two more things I want to say to you, but I'm kind of conscious this video is going on for some time. So I'm just going to stop the recording. Yes, sorry about that, guys. You can tend to get on a rant. I guess that's the basic, that's the basis of the Article 37 point in Zalewski. There's more to be said about it. There's one other thing I want to say about it. But I also want to remind you guys that there is a procedural rights element, and that's important. But you know what? It's actually dealt with in a very brief few pages at the end of O'Donnell's judgment, and it's more straightforward. But let me just show you. Oh my God, it didn't stop recording. Well, that's fine. Okay, well, I'm just gonna continue with the recording, because I'll just show you how O'Donnell felt that the jurisdiction of the WRC was limited such that it could be saved by Article 37. It's fairly simple, right? He points out that under the Workplace Relations Act of 2015, the WRC is very limited in the subject matter that it can consider. It's limited to considering only those employment law disputes referred to in the Act. Yes, that's a jurisdiction. It's a power. It has the power to deal with all these hundreds upon thousands of disputes in the domain of employment law, but it can't do anything else. It can't resolve disputes in criminal matters. It can't resolve commercial disputes. It can't deal with road traffic issues, and so on and on and on and on. It doesn't have any jurisdiction in respect of tort law, for example. It has no jurisdiction in respect of the common law generally. The High Court has full original jurisdiction, has jurisdiction over, it can develop the common law. A High Court can. The WRC can't, obviously. And I suppose that's probably the most fundamental limitation of the WRC. That's not to say it doesn't have considerable power. It's not to say it doesn't have a huge effect on people. Yes, it does. But is it a limitation? Yes. Is it a significant limitation? I would say yes, in respect of the jurisdiction. Does it distinguish the WRC from the High Court? Very much so. Very, very much so. Second obvious one, I suppose, is the level of awards it can make. So it's limited by statute. The Workplace Relations Act limits the awards that the WRC can make to basically to 2 years remuneration. Again, it's a limitation. Is there a limitation on the jurisdiction of the High Court in that respect? No. Under Article 34 of the Constitution, the High Court has full original jurisdiction to determine all questions and matters, whether of law or of fact. It's unlimited jurisdiction. There is, Donald O'Donnell said, limitation in respect of enforcement. Now, as we know, that's a very limited limitation in the sense that it's not really a limitation. Effectively, it has power of enforcement. But O'Donnell says, let's just recognize that there is a certain limitation there. He says it's limited by a right of appeal to the Labour Court. I mean, the Labour Court is not a court, by the way. But there is a right of appeal under the legislation from the WRC to the Labour Court, which is basically like the WRC, except a higher body, as it were. So, but that is a limitation. And in particular, I think the most significant, well, other than subject matter, I suppose, the most significant one is limitation by the right of judicial review. That is to say, like in Zalewski's case himself, you can't, if Zalewski, if you go to the WRC and it hears your case and it makes a determination in respect of your case, it determines what happened in respect of the facts, and it makes a decision, and you don't like that decision, you can't appeal it. You can appeal it to the Labour Court. You can't appeal it to a court, a proper Article 34 court. That's not possible. Right? But you can seek judicial review if there has been some egregious failure on the part of the WRC. For example, if the adjudication officer failed to observe fair procedures, let's say, it ignored your claims or whatever, you could go to the High Court and seek judicial review, right? And that is a significant limitation, in O'Donnell's view, on the jurisdiction of the WRC. So what Donald O'Donnell said, the judges in the majority and Zalewski said, was that these 5 limitations considered cumulatively. In other words, the implication is that any one of them on its own wouldn't have been enough, but taking 3, 4, 5 of them together, that cumulatively, they took the WRC inside the protective cloak of Article 37. In other words, taken together, they meant that the WRC was saved from unconstitutionality, right? So in that sense, Zalewski loses that aspect of the case. Now, of course, I stress again that what we're more interested in really is the transformation of how we approach Article 37 more generally, right? We move from an effect-based approach, okay, to a jurisdiction-based approach. And what that means in practice is that Article 37 has taken its place under the Irish constitutional sun again. In other words, it's now again a big deal, whereas previously it was more or less relegated out of the Irish constitution because it saved processes that didn't really need saving in the first place. Now it's kind of, and John McManamon says in dissent, he says, that's a mere saver clause. You've got the linchpin clause over here. You've got the saver clause here. And he says, what O'Donnell has done is he has elevated 37 to almost equivalence to 34. Whereas he says that because it's a mere saver, we should prioritize the linchpin clause. And basically he says that an autocrat, a would-be autocrat, in 5 years' time or 10 or 15 or 20 years' time would love that. Because now he can pass legislation that takes judicial power, what is really judicial power, and vests it in what he will call an Article 37 tribunal or body. And it will be a tribunal that makes decisions that has a huge potentially devastating effect on people's lives and reputations and fortunes and livelihoods, you know? So John McManamon says, I am deeply, deeply troubled by the judgment for that reason. So I really want to stop this recording right now, and will do.